Things not to do as a departing employee. New York Knicks versus Toronto Raptors lawsuit. The allegations contained in the lawsuit brought by the New York Knicks basketball team against their rivals to the north, the Toronto Raptors, impart some very important lessons for employees looking to leave one employer to start work for a competitor or on their own. Now, these are allegations, and they haven't been proven in a court of law. However, the lessons that they do impart are of practical consideration for all departing employees, and it needs to be distinguished from what you as an employee are entitled to retain and is legally your property, even though it might be stored on your employer's computer systems and email servers. So what exactly are these allegations, which have been leveled by one NBA basketball team against another NBA basketball team? Two examples set out in the lawsuit highlight the claims brought against the NBA Toronto Raptors and former New York Knicks employee that was hired by the Toronto Raptors. First, at paragraphs 40 and 41. On August 21st, 2023, Azatam sent two emails from his Knicks email address to his new Raptors email address at isatam@torontoraptors.com. In each case, the emails contained proprietary information with highly confidential material. He subsequently provided this material to the Raptors defendants at their request, including one email with the subject line "Forward Indiana Game 82" contained several documents, including an advanced scouting report of the Indiana Pacers players with team and player statistics, key plays and play frequency data, specific player tendencies in scouting, strategy analysis with offensive-defensive notes, play breakdowns, opposition play research, and transition. Comprehensive diagrams of over 250 Pacers plays, a spreadsheet containing play frequency statistics, and a spreadsheet containing the Pacers' play calls for a specific game broken down by game time. Second, paragraphs 55 and 56. On August 5th, 2023, Azatam shared 5 separate zip files with defendant Rajovic and defendant Lewis through a Knicks-operated SharePoint file-sharing website. Each zip file corresponded to a basketball position and contained video to individual Raptors players separated into videos of passes and videos of shots. The Raptors defendants viewed or downloaded the files on August 4th and 5th, 2023. In total, Azatam illegally shared 3,358 video files. The file share site was accessed over 2,000 times by the Raptors defendants. Misusing his access to the Knicks database and servers, Azatam conspired with the Raptors defendants to transfer thousands of files to the Raptors over the course of several days. The material at issue is clearly proprietary of the New York Knicks basketball organization, with the lawyer's citation of the confidentiality clause in the employee's employment contract only serving to reinforce this fact. For even if former employee Azatam was involved in the development of these materials, he was being paid by the New York Knicks to produce those materials, and as such, they were the exclusive property of the New York Knicks, to which Azatam had no legal rights. Now, without disclosing the specific of one's work, an employee would be capable of providing his prospective new employer an overview of the scope of the work that he undertook. And once he was employed and not subject to certain legally permissible restrictive covenants, he could undertake comparable work from scratch without the use of another party's proprietary information. However, by allegedly emailing the New York Knicks materials and information, the employee would appear to have conspired with the Toronto Raptors to steal proprietary information, resulting in claims of 1. Violating the Computer Fraud and Abuse Act, 2. Violating the Defend Trade Secrets Act, 3. Misappropriating trade secrets under common law, 4. Breach of contract, 5. Tortious interference with contractual relations, 6. Conversion, 7. Unfair competition, and 8. Unjust enrichment. This is not the situation an employee should place themselves in, such that employees need to recognize what information and materials are the exclusive property of their employer. At the same time, employees need to understand what information and materials they are entitled to and might properly share with their employment lawyer, and that would be almost all information and materials that is associated with the terms and conditions of their employment, including the most obvious aspects, including employment contracts, pay statements, termination documents, but also materials that were advanced to them related to their employment, including emails, letters, manuals, policies, and guidance, even though those materials might have been sent to a company email address. For unlike the materials that were allegedly sent by this now former employee to the Toronto Raptors organization, which the courts and the law will not condone, retaining and downloading your employment-related materials and information and sharing with your lawyer to assess any legal impropriety on the part of one's former employer is clearly distinct, with the specific advice of a knowledgeable lawyer always being the preferable course of action. This is a clear line as to what might be retained and for what purpose from one's prior employment. With the allegations contained in the New York Knicks lawsuit against the Toronto Raptors showing what is clearly not permissible, if proven, while there is a range of materials and information that are tied to one's employment for which the former employee has a legal right to retain copies of, provided that they were being retained for specific purposes, with appropriate legal guidance always being strongly recommended. For those employees looking to depart their current employer, it is always advisable to consult with a lawyer early on, such they are not crossing this line, while properly retaining employment-related materials that they are properly entitled to, especially where they are being retained for legal purposes. Thank you.